Why am I sometimes told I can only have 2 advocates meetings, other times as many or as ordered by the court?
Well, I'll come in here. I think we have to remember that the 2 event models, whether it's for single council or Queen's Counsel 2 council, developed at different times and came in under different fee scheme regimes that were applicable at different times. And they were also calculated in slightly different ways as a consequence. And therefore, for that reason, the position we take as regards advocates meetings has evolved differently. And it's as simple as that. So it is different for that reason for the 2 council and single council model. I think it's fair to say you only have to look at the event prices to realise that obviously there's a discrepancy in those event prices. And ultimately, it comes back to this position that I've said about events model generally, is that you need to look at the bottom line on the costs calculation with a view to the intention of the 2 schemes. They're intended to remunerate and provide reasonable remuneration for the life of a case. That is the intention of it. So again, we shouldn't be looking at individual events in relation to the schemes or trying to compare them in that sort of way. I don't know whether anybody else wants to come in around that, but
I can only mention what I was, from my experience. I've actually recently had a case where I had 2 counsel on it, and there was a single counsel from another party, just a junior. And within that advocates meeting they were having, the junior was going, "You can claim as many advocates meetings as you like." And I think that that's where it comes in, where there are 2 different schemes being operated, where the junior counsel is on his or her own are claiming as many as been ordered. And you've got the 2 counsel going, "Well, hold on a second, I can only claim 2. And I think it's just actually educating. It's just saying, please be aware. And I had this conversation, and as soon as I had a conversation with the Silk, it was like, "Oh, I understand now, Chris. Thank you very much." But the junior counsel was so adamant that they could claim, which they were right, it kind of feeds into it that they should be claiming more as well. But I think it's just trying to educate and communicate.
I'm assuming that a conversation around what is claimable for an advocates meeting under FAS and what is claimable under a 2 council event might come into play here as well.
Exactly, and even a single council event is exactly that as well. That they all have a chat around it, and you've always got. It's not wrong, but it starts to kind of bleed into their fear that they're not getting what they should be getting. Mm-hmm. But when you have the conversation about the guidance, it kind of clears it very much up, and then they know going forward that Silk is now basically can go back and go, "I know what the situation is. Thank you."
Next question is to do with a procedural aspect, and it's to do with billing after we've come to a final agreement. Why do we get requests for documentation when submitting a bill when we've already uploaded everything to the final case plan task, which is something that Anthony went through in the original process, in the first part of the webinar? I'd like to, because it's procedural and it's to do with CCMS and the submitting of bills, I'd just like to make you aware that you will receive an automated document request when you submit a bill. That's something that the system sets up. As far as high cost case bills are concerned, it's only for you to input a summary of case. And if that summary of case is all of my documentation is with the final case plan, that is fine. As the system will automatically send it to you immediately, so it's not delaying you time, it's not delaying payment, but it is something that you're required to answer. The other part of that, or the other part of the other reasons potentially, and I'll bring John Marshall in, and from a case manager's perspective, it's the documentation that Anthony was talking about, and sometimes the state of the documentation as to whether we can find things.
Well, yeah, it's exactly that. It's how you said it with billing. But unfortunately, CCMS it generates an automatic task for them to upload. So there is some duplication. I mean, I can't confirm that finance caseworkers will look into the case plan task and try and find the documentation. But I said previously, it's a lot easier when it's been, the description, it's clear what the documents are. So sometimes when a finance caseworker will ask for documents that have already been uploaded because they would have been missed. And obviously CCMS as user-friendly as it can be, we will miss documents. That's why it's important for them to upload documents and describe what documents they are, so then we get everything, and then hopefully we can obviously pay the bills on time rather than going back and delaying, and then causing delays to council and solicitors. It's just basically as simple as that. It's a system we've got to work with.
I think just from providers, from their point of view, I think it's a really good habit to get into, and just preparing one full composite bundle when you're submitting your final case plan. Just provide the LAA with everything that they need, and it really does make a difference in terms of how quickly you're paid.
Yeah, absolutely. I would add, if we do, or if the billing team send you something and you have submitted it previously, it probably falls into the category of it's not that easy for us to find in the first place. So yes, it's that whole making sure that when you upload your information, it's as easy for us as possible to find it, or otherwise you're doing yourself a disservice. We mentioned during the webinar underruns and overruns. We get questions all of the time, again, from the previous webinars. Can you explain when you can claim underruns or overruns, where a hearing is cancelled and perhaps relisted at a later date? Do you want to start with that one, Anthony?
Yeah, I'll pick that one up. That's fine. I think the best place to start is with the general position, which is that underruns only come into play in relation to main hearing days. I think that's general position number one. The second general position is that where a hearing day is adjourned to a later date, so you get to day 5 of a 12-day hearing, for example, and the next 7 days are adjourned later on, so they're not being vacated as such. Well, they are being vacated, but they're being moved. It's not a case that the case has underrun at that point. I think that's a good thought to have. If the days get adjourned at that point, it's not that the case is underrun. Those days are actually being moved to a later date. In that situation, there isn't an underrun, because it's just simply a repositioning of the case, effectively. So technically in that situation, you'd have no underrun. But what we've experienced in the last year are a number of exceptional cases that have moved and for good reason have been put off for a long period of time. So you've had situations where at the last minute, cases have been adjourned either partway through because something has happened as a consequence of the current pandemic that we've had, or before it started, but at very short notice. And the case has moved substantially. Now we're talking long periods of time into the future. In that situation, we've seen a lot of work being done by a lot of people, which may or may not be able to survive the period of adjournment or postponement. So we've had a look at that in terms of underruns in that situation, because I think the question has been asked in that context. And we've been amenable to underruns in that situation. But the general perspective of underruns is that an underrun is exactly what it says it is. The case is underrun. So that if you've got a case that's listed for 12 days, but it actually concludes at day 5, well, days 6 to 12 will be underruns because it underran. Equally, if with overruns, it's the same scenario. You've got a case listed for 12 days, but it actually goes on to day 15. The way days 13, 14, 15 are overruns because the case has overrun its listing period. If you get days listed beyond that because there's some other issue that's arisen, then in that situation, it's not part necessarily of the same hearing. It depends how it's been phrased. You can have a situation where a case is overrunning, but because of court time, it's not possible to do those days consecutively. So the court still overruns maybe a week later, potentially, but it's still part of the main hearing that was originally listed in essence. And the parties will have prepared on that basis, that it was effectively a 12-day hearing, but it's gone to 15, but the 3 days have had to be, because of the way that court is timetabled, can't be heard till a bit later. So that might, in that situation, be overruns. But again, for similar reasons to the COVID principles, we're keeping a mind open as to how we treat absolutely that situation. Now, I hope that clears up most of the questions. I'll wait for Scott, Chris, and Rebecca to come back into this just to make sure that they've got the understanding around this as well, that we're all on the same page.
I think one common misconception I've seen is sometimes solicitors thinking that if a interim hearing gets listed at short notice, they should claim it as an overrun, which isn't correct. Any interim hearings that get listed, because they have to come and go throughout the life of the case, urgent hearings have to be heard, they're paid as full events. There's no problem there. So it's a common misconception that I see. But I think for the most part, it is when a case is adjourned and then gets relisted at a future date, whether you can claim underruns and whether you can't. And the answer is that the LA will consider each case on its merits and look at what's happened in that specific case, in which case you need to provide justification. So you need to be putting it in your case plan. This is what happened, and this is why council's claiming, or we're claiming for those underruns, and make it very clear. I know, Rebecca, you'll have a much better insight.
I'm nodding so much. Yes. Yes, that's exactly what I was going to say. Just provide the justification, get that in your section A, just to explain what's happened, because so many cases can take a completely unexpected turn, and I think it's really good that they are considered on a case-by-case basis, really, rather than applying the rules so strictly in those situations.
Yeah, and I think asking council's clerk to provide you with assistance on that justification is really useful. I'm assuming that a lot of the time as providers, you won't actually be sat behind counsel at court and won't be doing sort of hand-holding them through the advocacy. They'll be doing it on their own. So it's getting their input as to what work they've done, you know, how much time they've spent on it, what the time scale is between the two hearings, what the complexities are in this particular case, and making it very, very clear. I've got a case where we've had 5 days of live evidence, and one of the advocates in the case has had to not withdraw, but has had to step out for a little while, and the case has been adjourned because of a family issue. And it's one of those awful situations where a family member's at death's door and is likely to pass away soon, but the court can't proceed without them there. We've already had 5 days of live evidence, and the court are trying to work out when to relist it, but they can't know that until they know when the advocate's going to be available. So this is just kind of a waiting game at the moment. So once we know when those hearings are going to be relisted, then we can assess whether we could potentially ask for underruns from the LAA and speak to them about it, because the court might not be able to relist the part heard hearings for months. And so everyone's going to have to stop what they're doing, forget that case, carry on with preparing new cases, and then go back and reread all their notes about the cross-examination that had happened already and what's happened. So in those circumstances, you can make the case to the LA and explain to them. But if you don't put anything in the case plan, then the likelihood is that it's going to be rejected, and the LA will say no.